today's webinar. On behalf of the National Council of Juvenile and Family Court Judges, the National Congress of American Indians, and the Tribal Law and Policy Institute, I'd like to welcome you to today's webinar. It's the first in our series of 3 webinars on protection orders. Today we'll be going over issuing protection orders in general. My name is Chia Halpern-Bitzo with the Tribal Law and Policy Institute, and we will also have Virginia Davis from the National Congress of American Indians on the line to help with going over questions. Today's presenters are the Honorable Stephen Aycock, the Judge in Residence at the National Council of Juvenile and Family Court Judges, as well as the Honorable Kelly Gaines Stoner, Victim Advocacy Legal Specialist from the Tribal Law and Policy Institute, and she's also a judge at the Seminole Nation of Oklahoma. Today's presentation will be about 30 minutes, and we'll have time for question and answer as well. And when you have questions, please feel free to type them in on the right-hand side of your screen. You should have a box, and within the docking station there should be something with questions, and you can go ahead and type your questions in there and we will get to them. With that, I'm going to turn it over to Kelly and Steve to get started. Thanks.
Good afternoon, everyone. My name is Steve Aycock. I'm the Judge in Residence here at the National Council. Kelly, you want to introduce yourself?
Sure. I'm Kelly Stoner, Judge Kelly Stoner, and as Chia mentioned, I work for both the Tribal Law and Policy Institute, and I am a tribal judge for the Seminole Nation of Oklahoma. Welcome, everyone.
So we're going to talk today. We have this 3-part webinar series that we would like you to join in with us about tribal protection orders. So the first one is about issuing protection orders. Next week at the same time, we'll be doing one on enforcing protection orders, and then on the 27th of September at the same time, we'll be doing one on the contempt powers of tribal courts and how they relate to protection orders as well as other cases in front of the tribal courts. As a result of today's session, you'll be better able to define protection orders and what they can accomplish in your communities, identify the legal requirements of federal full faith and credit as applied to protection orders, and create enforceable protection orders that contain the maximum protection available under tribal law. And first, we just want to talk a little bit about why protection orders are important. The whole purpose of protection orders, of course, is to provide safety for victims of domestic violence and their children and other members of their family and ultimately of the community, and also to keep batterers accountable. And so protection orders are the court's way of saying this is the parameters that it's of acceptable behavior in our community. And it sets forth clear commands from the court to the respondent. And it's important to remember that protection orders are not orders that require the petitioner to do anything or not to do anything. They are only orders that require the respondent to do something or not to do something. And ultimately, this takes away some of the power and control that the batterer has.
And when we talk, I'm sorry, didn't mean to speak over you, but when we talk about taking that power and control away from the batterer, I know if there are advocates on the line, and it really doesn't matter as long as you're working with victims what discipline you're in. Anytime power and control is taken away from the batterer, it becomes a safety issue for the victim. And so while we're talking about this presentation today, I would like for you to think about it with that backdrop, because everything that's written in that order, every command from that judge is taking power and control away from the batterer. So it's going to be critical. That's why we dedicate an entire session here to drafting protection orders. What comes out of the judge's mouth and what goes on that order It's going to be what's written on the order that's going to be enforced by law enforcement, because that's what they're going by. They don't have time to go back and listen to the record. So it's such a critical issue.
Next slide, please. Okay, and as Judge Stoner just said, it's not just in what the court says or even what the court says on the piece of paper. It's really what is on that piece of paper that can actually be enforced. And that's why it's critical that we have carefully crafted protection orders. You don't want a police officer at 2 o'clock in the morning looking at a protection order and not understanding what it is that he's supposed to be enforcing. All right, so when you have these carefully crafted orders, it promotes enforcement not only in your own jurisdiction, but in other jurisdictions if the violations are occurring somewhere outside the jurisdiction of your tribal court. It also promotes consistency in the enforcement across those jurisdictional lines, because under the Full Faith and Credit Act, other jurisdictions are required to enforce it as it was written by the tribal court, and that's very important. They don't enforce it as their own law would allow them to write a protection order, but as the tribal court and the tribal law says that the protection order can be written. And again, go ahead.
And if I could give an example of that, I'm here in Oklahoma today, so what that means here in Oklahoma, since we have checkerboarded jurisdiction, Indian country jurisdiction, is that when that victim gets that protection order, let's say in the Creek Nation Tribal Court, and they cross over, maybe across the street, and now they're on state land, that despite the fact that Oklahoma state courts do not allow you to really address custody issues in protection orders, if the Creek Nation Tribal Court issued a custody order pursuant to its own law in this protection order, and it meets the full faith and credit requirements, then the state of Oklahoma is required to enforce that protection order with the custody provision as that tribal court wrote it.
Absolutely, and that's so important because it's not just the whether this child support example. There's lots of other examples, including does it how long does the protection order last? In many states, protection orders are 18 months, a year, 18 months, 2 years, maybe 5 years. In other places, they can be lifetime protection orders. And again, it's the law of where it is written that gets enforced, not the law of where it's being enforced. So let's start at the beginning and sort of figure out what is a protection order. And because we're really talking about how to craft this order so that it gets enforced not only in your court but in other courts, it's really important to know what the Violence Against Women Act, how it defines full faith and credit. So as you can see from this, it's very broad. So it's any injunction, any restraining order, or any other order, and it can be issued by either a civil or a criminal court. And its idea is that it's being issued to prevent violent or threatening acts, or harassment, sexual violence, contact or communication, or physical proximity. Okay, and it includes any temporary or final order issued by a civil or criminal court. And protection orders, for protection order full faith and credit, it's a little different than firearms, and we'll talk about firearms later. But ex parte orders are in fact granted full faith and credit across jurisdictional lines. Anyway, it doesn't matter whether you have to file in your court for a specific petition to get a protection order, or whether you file a motion in a custody case or in even a landlord-tenant case or any other kind of case. if you are looking, asking the court to enter an order that does this, then it's a protection order. It also includes the information on the next slide. So again, it's any support, child custody, or visitation provisions. As long as it's being issued pursuant to your law that authorizes the issue of the protection orders. And it's for the purposes of protecting victims of domestic violence, sexual assault, dating violence, or stalking. So note that it's only the support, child custody, or visitation that has this limiting language about domestic violence, sexual assault, dating violence, or stalking. The subsection A does not. So just a regular restraining order would not require it to be within domestic violence. However, if you want to add support, child custody, or visitation, then it has to come within DV, SA, dating violence, or stalking.
Judge Aycock, I had an interesting question from a tribal prosecutor several weeks ago at a conference, and so I'm going to bounce this off of you since we're talking about it right now, and perhaps you can expand on it. The question was, this tribal prosecutor wanted to know that if the no contact orders that are being issued that this tribal prosecutor is requesting in cases involving domestic violence, if those would be considered a protection order, and how would she ensure that? Did she have to label it a protection order, or could it just say criminal no contact order?
It can just say criminal no contact order. Again, if you go back to A, if you go back one slide, so it's any order issued by a criminal court if the purpose of it is to prevent violent or threatening acts or harassment or this contact, sexual violence, contact, proximity. So it's really looking at the body of the order. Is there something in this order that says you cannot make contact with this person? That's sufficient.
So tribal prosecutors really can get into the to the role of also adding that next layer of protection if there's a criminal case pending. So I think that's an area we really haven't touched on that often, and I would encourage tribal prosecutors or advocates to mention this to their tribal prosecutors.
Yes. And you have to look at your own law to see what you can put into a criminal no contact order. Sometimes those orders, the statute refers you to the civil statute, and sometimes it will not, and it's very limited relief under your criminal law. But you have to look at your own criminal law to determine what can the judge do in a criminal no contact order. If that's not sufficient, then you ought to be helping or getting the victims to file civil protection orders to grant them the rest of the relief that they need to keep them safe. Okay, let's go ahead a couple now. So what's required for it to be enforceable under the Violence Against Women Act, full faith and credit? Right, so here really what it has to do. So the tribal court has to have subject matter. Actually, it's the issuing court, wherever it might be, whether it's tribal or state or territorial, local. So they have to have subject matter jurisdiction. They have to have personal jurisdiction. There has to be a notice and an opportunity to be heard at some point for the respondent. But an ex parte order is, like I said, is going to be enforceable as long as the respondent is going to be given notice and an opportunity within a reasonable time. And then finally, that the order has not expired. Obviously, if the order is expired, then there's nothing that you could enforce anyway. And we want to talk first a little bit about jurisdiction. So here is the statute that actually says under federal law, not tribal law, but under federal law, what the tribal court's jurisdictions are. So this is the same section that just defined what a protection order was. Right? So tribes have full civil jurisdiction to issue and enforce protection orders involving any person. So I've got the issue and language in bold because that's been added by VAWA 2013. Before that, those two words were not in this statute. And there was a federal case that questioned whether or not tribes had this jurisdiction to issue them, because it said, well, it doesn't say issue, it just says enforce. So in VAWA 2013, they put in these two words to make it clear that tribes have this. And notice it's involving any person. So it doesn't have to be a tribal member, it doesn't have to be a member of another tribe, and it can be non-Indian, Indian, Native, immigrant, whoever, any person. And it includes this authority, then you can enforce it through civil contempt, you can exclude people, or you can use other appropriate mechanisms. And so it's anywhere within the Indian tribe, the Indian country of the tribe, or otherwise within the authority of the tribe. So if you have the authority over a piece of land and an incident occurs on that piece of land, you then have jurisdiction for the purposes of the federal statute.
I want to say a word, just point of clarification here, because Judge Aycock pointed out this is federal law. So the first thing I would want to do if I was working in tribal court is get out the tribal code and make sure that the tribal code by its own terms, and possibly we need to reflect on the tribal constitution as well, by its own terms also allows the court to exercise this jurisdiction. Because this particular provision did not change tribal law per se.
Correct. And when you're looking at it, what you really want to do is make sure that there's no limitations, either in your constitution or in tribal law, about who can get covered and who can ask for who can ask for a protection order. Now, that you may have some limitations in terms of age. So sometimes under the age of 18, tribes and other jurisdictions have certain limitations. So perhaps from 16 to 18 they can file their own. Perhaps they can't. Maybe they have to have a parent or guardian, or they have to come to court and get somebody to issue it for them. But other than that age restriction, you want to make sure that it's as broad as you can make it and still fall within this jurisdiction, this federal jurisdiction language. And so, as you know, before I read you that protection order or that PowerPoint about what's required, and I just want to go through sort of those requirements. So first we said it has to have subject matter jurisdiction. So what does that mean? That's just the power of the court to hear the general type of case before it. So you want to make sure that your tribal code says the tribal court may issue protection orders. You want to make sure that there's something like that in your code. There's a recent case out of Florida and Georgia, or Florida and Alabama, excuse me, that went to the U.S. Supreme Court about full faith and credit. And the Supreme Court said all it has to say is that this court has the power to do that. If they have the power to do that general type of case, then it's covered, and subject matter jurisdiction is going to be covered. Then personal jurisdiction is what's the legal power of the court to render judgment over a specific person. So this is now where there has to be some kind of connection to your jurisdiction. And again, you want to look at your statutes to see what it is. So for instance, there may be some tribes that say the tribal court only has jurisdiction over tribal members, or it may say it only has jurisdiction over members of a federally recognized tribe, whether their own or some other tribe. So you want to make sure that, again, for personal jurisdiction, that it covers everyone, but again, it has to have some connection to your community for there to be personal jurisdiction. That's also going to require notice. But before we get to notice, Judge Stoner, anything you want to add on either subject matter or personal jurisdiction?
Well, you know, I can't pass up an opportunity to shout out. So I'm going to say, I remember personal jurisdiction to myself as the defendant that you're pulling into the court has enough contact with that jurisdiction, with that tribal court, with that Indian country, so that it doesn't seem unfair for the court to be exercising jurisdiction over a particular person. And so when I'm thinking about things like that as a judge, I'm thinking about, are you married to a tribal member? Have you been in the Indian country to visit? Do you live here? Do you get services here? You know, just kind of looking for that person's contacts, and I like to get those on the record. And when I'm drafting a protection order and I get to these two pieces, and I know we're going to go into that more specifically in a few minutes, one of the pieces that I want to highlight and bold and underline, and Judge Aycock said it earlier, and I think we need to say it several times, it's not enough to just say this tribal court has subject matter jurisdiction over this matter. It's not enough to say we have personal jurisdiction over the respondent or the defendant. We have to explain why. And it's wonderful if you can look to your tribal code and say we have it because the tribal code, this particular section says it does, and we have it because these particular pieces of evidence indicate we do. And then I'll turn it back over to you.
Okay. So let's move on then to notice. So what is notice? And again, it has to be sufficient to protect that person's rights to due process. And tribal courts are free to determine what due process parameters are for themselves. But I think if you think about it, and what many courts have said is due process is really this idea of fundamental fairness. And as long as it's fundamentally fair what you're doing, it's going to be okay. So a person has notice if they have actual notice. So if somebody told them that there's a protection order, they actually got a copy of the order, or they have some reason to know about the protection order. So those three things would indicate that the person has had notice. Again, this will be a little different when we get to firearms, but we'll get to that one in a few minutes. So what happens if you don't have those things? If you don't have subject matter, personal jurisdiction, you don't have notice? Well, the enforcing court may refuse to enforce it at all. They're not required to. They may, but they are not required to. So if it meets all the VAWA full faith and credit requirements, they are required to do so, to enforce it. So they either may refuse to enforce it at all, or they may say, well, we can't grant custody here in this state, so I'm not going to enforce the custody piece, but I'll enforce the no contact piece. So you don't know what's going to happen. So that's why it's vitally important that not only that you meet the requirements of your own code, but that you also meet the requirements of the Violence Against Women Act. Now, I know that...
Oh, I'm sorry. I keep talking over you. I'm sorry. I wish I could see you. If I could just... If I could add to this that, you know, I know, as and probably you too, Judge Aycock, as we move across the United States, we oftentimes hear complaints from tribes that states will not enforce their protection orders. And so I know there can be a whole host of reasons, you know, the state might give for not enforcing it. But I think one of the messages Judge Aycock and I would like to get across to everybody today is if your protection order contains enough language that meets the VAWA full faith and credit requirements, it doesn't just write it in there, it also it supports it with tribal citations, it supports it with evidence that was presented at the hearing, then the state court really doesn't get a choice. By federal law, the state is required, mandated, to enforce that. And I know putting words on a piece of paper is not going to make everything better and all states comply. But I mean, I think that's the first thing I would want to look at if I were working in a tribal court and I've got a state that won't enforce the protection orders, I'm going to say, well, first of all, let me do my homework, make sure that I have met these requirements, and then I'm going to reach out to either a tribal coalition or the Office of Violence Against Women to say, we're having all kinds of trouble here getting our protection orders enforced. So crafting and drafting of that protection order, what's in it, may very well determine whether or not it's going to, you're going to have that argument that the state is mandated to enforce it, that it being the protection order.
And it's important to try to figure out where's the breakdown in the state. Is it because the police won't enforce it? Is it because the clerks are doing something to stop the enforcement? Or is it because the judge just won't do it? It's really important to try to figure that out. And then I would just say that between NCAI, TLPI, and the National Council, if you would let us know if that's happening in your community, we can at least discuss with you some technical assistance that may be helpful. And obviously, to the extent that either the petitioner or the tribe, if the tribe wants to help, can do an appeal from the state, then that's great. But the appeal is really going to work when it's the court, the judge, who's actually the one who's saying, I'm not going to enforce it. If it's the police or the clerks, then other legal avenues can be taken. But there's also avenues that can be taken short of litigation. And so please let us know if that's a problem in your communities. And then I'm going to turn over the next couple of slides here to you, Judge Stoner.
Okay, sounds great. So this slide is really addressing jurisdiction over non-Indians on non-Indian land. And if you'll, I know you probably can't remember in your mind that first slide we went over, but the VAWA 2013 was saying that tribes shall have jurisdiction, both civil, it'll have jurisdiction to issue and enforce civil and criminal protection orders in matters arising in Indian country or matters otherwise within the tribe's authority. And that's where this comes in, this particular slide. It's particularly applicable here in Oklahoma or in other tribes that have checkerboarded jurisdiction, and possibly in Alaska as the Alaska tribes begin exercising jurisdiction as well. So if the tribal court judge is going to issue a protection order and the matter itself did not arise in Indian country, and this also involves non-members, so that's crucial as well. And I'm going to give you an example. I'm the Seminole Nation Tribal Court Judge, and the code says that the court's jurisdiction is Seminole County. Now that is not a reservation, arguably. For today's purposes, it is not. And there are pieces of checkerboarded Indian country within that particular county. But Seminole Nation has identified this as their reservation boundaries. This is where their piece of land was given to them by the federal government. And this is what Seminole Nation addresses as their service area. So if you're an Indian person within their service area, they're going to say you're eligible for services. So they reach out and work in this entire service area, even though the lands within the service area are checkerboarded Indian and non-Indian. Okay, so when I get in front of me a Seminole Nation tribal member versus a non-Indian, and the tribal member would like to have a protection order, I think that if the matter didn't arise on trust land or Indian land in Seminole Nation, I may have to meet the Montana case. I say may because no one is absolutely certain, and I like to think that judges go as far as they can to protect victims. So I'm going to be ultimately safe and do everything I think may apply. And this particular case it's from the United States Supreme Court. You can kind of see it there on the slide, what year it was issued. It gave everyone a test to determine whether a tribal court has jurisdiction over non-members. Now again, I have to first look at my tribal code, and if Seminole code says I do, then I'm going to be thinking, okay, in Seminole Indian country, I know this order will be enforced. But what if that victim gets outside of trust land, outside of Indian country? So when we think about that, if we go to the next slide, we'll talk about the test really quickly. And this is why I want to just reiterate that when you talk about subject matter in your protection order, the check the box piece, unless it's just tribal members on tribal land, the check the box is it's not the best way to do this. So the first prong of this Montana test, parties entered into a consensual relationship with the tribe or its members through commercial dealings, contracts, or other arrangements. Now, I would argue that if you marry a tribal member and you have children and you enroll them, we start looking at all the actions that can equal consent, a consensual relationship with a tribal member, and we're going through other arrangements. So I'm thinking about all that, and I'm wanting to hear evidence on that. The second is that the conduct that's at issue here, and this is going to be domestic violence, threatens or has some direct effect on the political integrity, economic security, or the health or welfare of the tribe. If you meet either one of those prongs, if the tribe meets either one of those prongs, if the case is appealed, theoretically, the Fed should recognize that the tribe had jurisdiction, and so should the states. So I'm thinking as you're writing your codes and as tribal judges are listening and advocates are presenting with their victims in tribal court, it is going to be very important if you have anyone other than 2 tribal members standing in front of their own tribal court that you at least touch on these 2 prongs. And when tribes are redoing their codes or modifying their codes for special domestic violence jurisdiction, it's a great time to go ahead and put in there some legislative history or purpose that talks about how domestic violence has threatened the political integrity, economic security, or health and welfare of the tribe. I think Tulalip did a good job. If you look at the Tulalip Code, you'll see that. And so again, this particular test, I, as a judge, am going to be incredibly attuned to if I have anyone that other than 2 Seminole members in front of me at the Seminole Tribal Court. I'm going to go back through and try to get evidence to meet these prongs. And I'm going to make a finding that I've met the prongs.
And here's just an example of that. You want to do these next 2?
Yeah, I think this is sort of a you make the call as we are talking about subject matter jurisdiction, and we're pretending this is a tribal court protection order. And so let's look at what this says, and let's decide in our minds whether we think this is enough. Okay, so what we have is we've issued a protection order. Let's say we've had, it's me, I've issued it, I have a Seminole member, and I have a non-Indian in front of me, and the tribal code says I can issue the protection order. And all I have written is this court has reviewed the petition for domestic abuse protection order and the motion for the temporary order in this case, and this court has subject matter and personal jurisdiction. Is that going to be enough if this protection order is violated in state court? Is that state court going to look at this language and say, well, clearly the tribal court had jurisdiction, and clearly that was an issue that the tribal court really took evidence on and made findings on? Or would you rather see the next slide? And this is written in its place, that the court has jurisdiction. It cites to the tribal code, which, by the way, is made up. It's talking about where the parties live. It's talking about people being employed with the tribe. It's talking about whether people are non-Indian and members of the tribe. It's talking about where the violence occurred. So which one do you think would hold up better on appeal? And it's going to be the one that has the most information and finding by that tribal judge. And it's sort of a message to appellate courts. If the judge, if you can actually look at the order and see what kind of evidence the judge took and follow the judge's thinking and rationale, you shouldn't disturb that unless it violates the black letter of the law. And so I would argue that the second one is much better.
Thanks. And then we just wanted to throw this in. We're going to actually talk a little more about firearms next time when we talk about enforcement. But so if you're subject to a qualifying protection order, while that order is in effect, you're prohibited from possessing any firearm. But the statute requires it to be a qualifying protection order. So what does that mean? Well, it has to be issued after a hearing in which the respondent had actual notice. So he actually knows about the hearing. And he had to have an opportunity to be heard. That means that it cannot be one of the temporary ex parte where it's just one party that goes in and gets an order. This has to be, this protection order would have to be done after there is, in fact, an opportunity to be heard. Now, they can waive that opportunity, but you have to at least have given them an opportunity to be heard. It also must restrain the person from one of these two subheadings here, either harassing, stalking, or threatening, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury. Okay, and it must also include, so it has to do one of those two. It has to restrain them from one of these two, and it also has to include a finding that the respondent represents a credible threat or an explicit prohibition against the use, attempted use, or threatened use of physical force. So obviously, if you explicitly prohibit them from using, attempting to use, or threaten to use physical force which would cause bodily injury, you are also restraining them from the second one up here, engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury. So it doesn't end up having that you have to have two separate sentences, although that's best. It's best if your form actually has both of these on there, so that it's very clear that, again, that the court has done what it needs to do to make this a qualifying protection order. And it doesn't do any good to have a little box on the form that says, this is a qualifying protection order for the purposes of firearms prohibition. That doesn't tell anybody anything. So it really does have to have this language. So let's again talk a little bit about what language should be in there. And to start that, I just want to reiterate again why language is important. Right? So this language can tell us whether or not it's going to get full faith and credit in other jurisdictions. As we just said, it may trigger federal firearms prohibitions. It could be the basis for a similar thank you. For a civil or a criminal prosecution, right? So it could be the basis for a civil contempt order, or it could be the basis for a criminal prosecution of either Indians or, under VAWA 2013, of non-Indians. It can form the jurisdictional basis for custody. So under the Uniform Child Custody Jurisdiction and Enforcement Act, there are provisions that even if the child is not in their quote-unquote home state for the purpose of the UCCJEA, this Uniform Child Custody Act, there's emergency jurisdiction that can be taken if there is domestic violence. And so a finding that there's been domestic violence in a protection order can actually then form the jurisdictional basis to go forward with custody. And then finally, depending upon where this occurs, a lot of jurisdictions now have presumptions about custody, so that the presumption is if there's a finding of domestic violence, then the batterer, there's a presumption that they would not get joint custody, or that they would not get full custody, or in some places it's actually the presumption that the custody would go to the nonviolent parent. So there are lots of things in the language of a protection order that can be very helpful, not only for the safety right now, but to help them going forward in other litigation. So what should be in the order? Specific, concrete language, right? That's important, and that's sort of what we've been talking about. Rather than saying, I have subject matter jurisdiction, you actually say why you have subject matter jurisdiction. Rather than saying, stay away or no contact, you say, what does that mean? What is it you really want them to do? Do you want them to stay more than 300 feet away? Then say they want that. You want it to make sure that it meets all of these requirements we've talked about. So again, first, does it meet your constitutional and tribal codes? Does it meet VAWA? Does it meet full faith and credit? Does it meet federal jurisdictional law? Again, you want some language that's going to be clear enough for an officer in the dark at 2 a.m. to be able to enforce this. The better you have it written, the clearer it is what it is that this person must do or cannot do, the easier it is for law enforcement to enforce. And then, again, for the same reasons, it then allows your court or another court to easier enforce it, because there's no question about what it is that you meant to do.
Can I add just one little piece to that as well? I would say look at this also, especially the remedies section of your protection order. The remedies, you're saying, like Judge Aycock said, you stay 300 feet away from the petitioner at all times, that you not sexually assault the petitioner, that if you arrive at any place the petitioner might be, that you must leave, that the petitioner will have custody of the children. All of those sorts of things. I want you to look at your remedies when you get them written, and their advocates know that these remedies have to be tailored for every single client. So you're looking at them, and look at them as a tribal prosecutor might look at them. Did you write those clearly enough that I can show, I can demonstrate beyond a reasonable doubt that the defendant violated one of those provisions, one of those remedy provisions? And one of the things I would be thinking about is an example I might give you. If you say simply no contact with the petitioner, and the defendant says, okay, I'm going to get my cousin to go over and talk to the petitioner for me, and I'll just send messages through my cousin. If, in fact, you didn't say no third-party contact, there's no violation technically there. So you've got to be looking at those remedies, and did you word those tightly enough that a prosecutor can look at the evidence and say, oh, yeah, I can show that beyond a reasonable doubt. That was violated.
And we can skip these next two. This is just a repeat, I'm sorry about that, of what we just did. One more. Okay, so, but here's some language now about notice, and it's using that Dear Nation again. So rather than again say respondent got notice, the respondent was given notice of today's hearing by the Dear Nation Tribal Police Department. Proof of service is in the court's file. Okay, now there's no question now that there is in fact service. There's been notice given to the respondent. Or you could say, this is an ex parte order. The final hearing is set for this date. He will be given, or she will be given notice of today's hearing and this order prior to that hearing. Okay, so you've met those requirements of the statute when you say those things. And again, be specific as to who it covers. So don't say petitioner and her children, although I say that later, but it's a little, you want at some point to actually identify them. And this is important because for purposes of VAWA 2013 criminal prosecution for violation of a protection order by a non-Indian, a victim is only those who are specifically covered by the protection order. So you want to state their full names, their identifications if you can. birth dates, something that identifies them. These are the people we're talking about. Again, as Judge Stoner just said, you know, be specific, right? And then this last one is the same. You have no communication through third parties, including family members, no electronic, telephonic, social media communication. I mean, you want to make sure that it's broad and it's really covering things. And one more thing before we get to these learning points, I would just say, well, so we can go ahead to the learning points because I think it's actually in there. One more. So look at this last bullet point here. We know that one of the main reasons that victims tend to go back with their abuser is either because of their children or because of economics. And sometimes those two are combined. So if I've been isolated, I'm not working, I don't have any income, I've got 3 children, I've now separated from the batterer, well, but I don't have any way to feed my kids. I don't have a home. I don't, whatever it is that you may need economically, you don't have those things. So what's the answer? Well, if you have family, you can try family. If you have friends, you can try friends. But the reality is, for the long term, oftentimes what we see is survivors going back to their abuser because they don't have the economic ability to sustain themselves separate and apart from the batterer. But again, so make sure your orders have all the requisite elements for your tribal law, for VAWA full faith and credit. Make them as detailed as necessary to protect your victims and hold the batterers accountable. And again, as we've said several times now, you know, if they comply with the requirements of VAWA, they're enforceable in every jurisdiction. And just so you know, I know for those of you who may be along the northern tier, I don't know if they're working with Mexico yet, but the State Department is working with Canada on trying to get some language between the two countries that would give full faith and credit for protection orders issued in Canada, in tribal or in United States, and United States protection orders issued in here would be granted full faith and credit in Canada, and they're including tribal courts in that when they say if it's issued here in the United States. And then I think we said this right, box checking is not enough. You really need to say what it is you want it to say. And then this last one, again, this is the one that Judge Stoner went over. Make sure that you have the correct subject matter and personal jurisdiction in there, and if that means that you need to, or you think you need to meet the Montana test, meet the Montana test. There's nothing wrong with having too much. I mean, you know, making sure, as Judge Stoner did, you know, making sure that I'm actually protecting them, and if I need to, you know, put in 47 nails instead of just 10, let me put in 47 nails and make sure I get it covered. Then I just have some things here at the end of this, and Chia, they'll be getting these PowerPoints, right?
Yes, I'll email it out to everyone.
Okay, so you'll have these resources, and the very last one then is how to contact Kelly and I. But I would tell you that my phone number on here is wrong, and just so you know, I did this. So 775-507-4802, but my my email's not on there either. Maybe we can put that on before we send it out.
Yeah, I can put your email on and correct the number before we send it out.
Okay, thank you. So what we'd like to do, and let's, Judge Stoner, is there anything else you want to say before we open it up for questions?
No, I think we covered it all. Thank you.
Okay, so we want to open this up for any questions that you might have. And here's where we're going to call in Virginia Davis to help answer some of these questions if we have any.
Yes, I'm happy to. So there's, in your control panel, there are 2 options for raising a question. You can either click to raise your hand or you can type your question in the box. Either way, if you click to raise your hand, I can make sure your line is unmuted.
Or if you want, you can type into the chat.
I'm not seeing any questions at this time, Stephen. Kelly, I know that you had also wanted to share the protection order website resource. Is that something you'd like to do now, or something we should send out to the panelists?
Is that TLPI? Or is that VAWA, yours?
You know what, actually now we have a question. The question is, are you working with InterTribal Courts? And does that work?
So is the question about when there's multiple courts that are, multiple tribes that are using one consolidated court? Is that how you understand this?
Yes, I think so. The question came from Juana, and I can see, Juana, it doesn't look like you have audio access for me to unmute you at this time, but if you want to type any clarifications in, and we'll try and get Juana able to speak.
Yes, I mean, well, I'll let you answer it, Virginia, if you would like to.
You can go ahead while I deal with this technology issue, if you don't mind. So, yeah, the question is just about the InterTribal Courts.
Okay, and somehow I'm not seeing that, the questions, but maybe it's just because of I'm not much for technology either. Yeah, the only thing I would say is if you have an intertribal court, the judge has to make sure that they understand what the codes of each of the individual tribes making up that intertribal court, what those codes say, and what the constitutions of them say in terms of jurisdiction, what relief I can give, and those kinds of things. So you may want to think about, if it's not already been done, that the tribes get together and have common language in their codes so that it's easier for the judges to make sure that they are complying with the code. That would be my only caveat. Other than that, there should be no problem. It's a tribal court. It's issuing an order. If it meets the requirements of the Violence Against Women Act, it's to be enforced in any other jurisdiction.
We've got a couple more questions. I'm going to, Donna McNamara, I'm going to unmute. Oh, shoot. What did I do to you, Donna? I made you disappear. Can you raise your hand again, Donna? Sorry about that. All right. I think Donna's line is unmuted on our end now, if you want to go ahead with your question.
Sure. In reviewing the all the material that's been presented, I would love to be able to share this webinar, not just the slides, but the whole presentation with our DV advocate and with our my fellow prosecutor and with the judge. Is that resource going to be available, or is it only the slides?
We are at TLPI. We're going to work on getting that onto the Tribal Protection Order website. But as soon as that's available, I can email out that information to the group when we get it set up.
Any idea of the time frame?
I am not sure. I need to talk with our tech folks.
Sure.
I'm not good at that stuff, but I will get on it as soon as possible.
Thank you very much.
So Chia, this is being recorded today?
Yes, it is being recorded right now. Yep.
Great. Great.
And so one of the things I would suggest...
Feel free to share with anybody.
Yes.
Thank you.
If we could point you also to the www.tribalprotectionorder.org. That is a website put together it sort of provides some resources and live links so you can click and actually look at VAWA 2013 while you're looking. It gives you some suggestions on drafting tribal protection orders. talks about enforcing tribal protection orders and those sorts of things. So maybe that would, I think we have that on our resource page. I think that might be helpful too.
Great.
Great, and I'm going to go ahead, we've got a few more minutes and several more questions. So I'm going to go next to Michael Swallow. I think your line should be unmuted. We can't hear you, so check and see if it's muted on your end. All right, so I'm going to go, we also have a few questions that have come in writing, and we'll come back to Michael Swallow in a minute and see if we can figure out the technology issue there. Teresa is asking, if an order gets issued and asks for economic relief, how is that enforced? In working with the state court, it's been said to me that there's no way to collect that money. The victim has to get an attorney and go to civil court. The clients we work with cannot afford an attorney. I'm an advocate in Oregon on a reservation.
Well, you should also be able to enforce it through civil contempt. So you should be able to take your order to state court and then tell the clerk you want to file a civil contempt to enforce the order. And that should start the process of getting it done. Some jurisdictions, if they're not paying economic relief, there can be a problem in terms of they may not criminally enforce it, but it should be civilly enforced anyway.
And I don't want to rule out, though, criminal enforcement, Judge Aycock. I understand what you're saying, because there has to be the person had to first be capable of complying. If they didn't have the money to provide the economic benefit, then obviously they can't be held in criminal contempt. But I have seen tribal judges ask questions such as, you know, have you gone to the movies? Do you smoke cigarettes? Did you go out to dinner? Have you been to the casino? Well, that money could have gone for this, and find them either in civil contempt or use that the prosecutor can use that information in a criminal contempt type situation.
Yes.
We're getting feedback here, I think.
Right. The other thing that you can do is the tribal court could actually require the individual to sign a voluntary garnishment of wages if there are wages. And then, I mean, and so that can be enforced in tribal court as well. And, I mean, it's always a problem trying to get the non-Indian to come back onto the reservation, but ultimately, if they're served with notice of a hearing and they fail to appear, the court could always issue a warrant for their arrest for failure to appear. Again, you may want to make sure that that's language in your code.
Another idea as well is to the judge can force the defendant to post a bond if they have a history of not paying, and that they'll forfeit that particular bond if they're late on a payment. So there's just a variety of creative ways to get at that economic issue.
We're going to go to the next question. Is there a typical time period protection orders are in effect? The questioner says their code is silent on the length of time. They typically enter them, quote, until further orders of the court, ...
I don't know that there's a typical length. Like I said, I would guess somewhere between 6 months and 5 years is generally what you see in codes. But again, there's nothing that requires that. I would feel more comfortable if that's what your court's doing, of amending your code to say that the protection orders last as long as the court says they do, up to and including lifetime of the petitioner or the petitioner's children, if they're included as well. I just think in terms of if somebody is doing some kind of collateral attack, or even in your own court saying, well, you know, it doesn't say how, your code doesn't say that this can last this long. So, but there, as far as I know, there's no typical time.
Great, thanks. Then we have, oh, sorry, go ahead.
I was just going to ask Judge Stoner if she knows. Have she?
I would agree with what you're saying. I agree 100%. I've seen them across all over, 2, 3 years, 5 years, and in certain jurisdictions they'll say they'll allow, if there have been violations, for you to get a lifetime order. So I think again.
Oh, did we lose Judge Stoner, or did we lose me?
No, you're still here.
I'm here.
Okay.
I think I'm going in and out. I don't know how much you heard of what I said, but I've seen it across the board.
Okay.
Thank you. So we have another question asking if tribes of an intertribal court have a full faith and credit relationship, can the protection order of one tribe apply within the other tribe's land base? Yeah.
Absolutely. So it's the full faith and credit applies to any other jurisdiction, tribal, state, territorial, local, doesn't matter. So if the court is ordering it, it's enforceable in the courts of other tribes, even if they're all part of the same intertribal court system.
Great, thanks. And then the last question is another one from Juana. Does the habitual offender provision apply with separate tribes within the intertribal court? And I think I'm assuming there, and hopefully she'll type in and clarify if this isn't correct, but I'm assuming that she's talking about the federal habitual offender provision. And and that provision requires makes it a federal crime after a person for a third offense if a person's been convicted twice previously in state or tribal court. And the way that federal provision is drafted, it wouldn't matter. Those two tribal convictions don't need to be from the same tribe. They could be, or they could be from other tribes. I don't know, Judge Aycock or Judge Stoner, if you have anything else to add or a different interpretation of the question.
No, I absolutely agree. It can be two states, a state and a tribe. It doesn't matter as long as there's two previous convictions.
I agree.
Did you ever get Michael?
We did. He typed in the question about the time period for protection orders. Oh,
okay. And I guess it's Judge Swallow, right?
Yes, I think so too. But
okay.
Are there any other questions? I think we've gone through everybody who's typed in or had their hand raised. Great. Well, Chia, I'll turn it back over to you for any closing comments. I know we're a few minutes over our allotted time.
Okay. Thank you, Virginia. Thank you, everyone, for joining. And we will definitely, I will get the slides out to everyone. And just a reminder to please feel free to join the webinar next Tuesday and the following Tuesday, same time. So if you haven't registered, please go ahead and register. And I will also get information out to everyone about when the actual recording will be posted and where. And with that, thank you, Virginia, Kelly, and Steve. And I guess everybody have a great day, and we'll talk with you again next week.
Thank you.
Hi, everyone. Thanks for joining us.
Bye.